So good morning, everybody. As I say, I'm James Kidd. I'm joined by my colleague, Rebecca Cockerill, and together we're going to attempt to talk to you about anti-harassment issues. This is a webinar designed for in-house counsel. I know not everybody on this webinar is from in-house counsel, but the majority are. And what we're going to cover today is what is harassment, and we're going to run some scenarios to that effect, and there's a little bit of engagement for you all. We're going to put some polls up and you have to tell us whether you think it's harassment or not. We'll then look at the legal context and the consequences of harassment. Rebecca's going to talk about reasonable steps developments and then recent developments. So we'll go for about 45 minutes. It's being recorded. There are Q&A available if you want to ask us some questions, and if it's appropriate, we'll deal with it at the time. If not, we'll deal with it at the end, depending on how we manage this. And then there'll be a feedback pop-up. As you leave, please do complete the feedback form, and I'll try and remind you at the end. Okay, are you ready, Rebecca?
I'm ready.
So I'd like to talk to you first of all about the Faucet Society. So this is a society which is promoting women's rights, been around, I think, since 1866, but happy to be corrected on that if I'm wrong. And as you can see from the slide, they did a report in October last year, which had some very alarming findings. And if you read those for yourself, that would be helpful. So this is the report. This is old school. I'm holding up the report. And what I'd like to do is ask you all to humour me whilst I read from the key findings of the report. I found that this encapsulated so many of the issues that we're going to be talking about today that it was worth spending just a couple of minutes whilst I read this to you. So please bear with me. So, executive summary. In July 2021, the UK government committed to legislation for a duty on employers to prevent sexual harassment, following campaigning by Faucet and other groups off the back of the Me Too movement. This move recognises that sexual harassment is not just about the aberrant behaviour of a few individuals. It is about a culture within workplaces where everyday behaviour which violates the dignity of predominantly women is too often treated as acceptable banter. At least 40% of women, which you can see on the slide, have experienced workplace harassment, and women who are marginalised for other reasons, such as race or disability, face an increased risk at different forms of sexual harassment. This culture is upheld by the way many employers approach sexual harassment, seeking to quietly resolve incidents after they've happened and to minimise liability. This approach is an individualized response to an institutional problem, and it can make things even worse for employees who report sexual harassment, who can face victimization and retaliation. Women often recognize this risk and choose not to report at all, leading to a vicious cycle where managers and leaders do not know what is happening in their organizations and policies sit on the shelf unused. Environments like this hold back employers who want to create a diverse, productive, and people-focused organisation, and can reduce profits if employers have to pay employment tribunal fees and legal costs for failing to protect their employees. I really think that that encapsulates so much of what this is about. Last quote from this report: our review of the current research identifies 5 key requirements to create a workplace that does not tolerate sexual harassment: culture, policy, training, reporting mechanisms, and the way employers respond to reports. I would urge you to have a look at this report, which goes into those 5 key points in more detail. It is definitely worthwhile reading if you are interested in this subject. I hope whilst you were listening to me, you glanced at the side to see some very high statistics of what is happening in workplace harassment. And that's why we're here today, because actually, you might have thought, well, post Me Too, or if Me Too has finished, surely everybody knows that we shouldn't be tolerating this type of thing and put in place practices, as Rebecca and I's lives as employment lawyers will show. Actually, we're still getting the queries, we're still getting the client saying, X is doing this to Y, what do we do about it, and how do we typically get rid of somebody? So it's still happening, and we still need to deal with it. And as employers, we need to be managing this and minimizing liability. And we'll come on to how we deal with that later. So this is a serious subject. If there's any levity in this webinar, it is only as a way of us engaging with you. We treat this as a very serious subject. What we have now is 5 scenarios where we're going to ask you to engage via the use of the poll to tell us whether you think it's harassment or not. Are you ready, Rebecca?
I am. And I'll just say, obviously, we appreciate we haven't actually gone into detail as to what harassment is yet. So it is just your gut kind of instinct of whether you think this would amount to harassment or not. So Arthur sends a picture of a bikini from his work email to his executive assistant, Maria, with the comment, "This would look good on you." Maria is surprised and shocked by this. So do we think this will amount to harassment for the purposes of the Equality Act?
Please vote now.
Yeah, just waiting for them to, not a surprising result, I have to say, so far.
That's about 94%. Are you happy for me to end that?
Yes, go for it. Okay, so you'll see that the 94% think yes, and a very small majority think no. So the answer is yes, this would amount to harassment, and those no may be because it's a one-off instance, but case law has been clear that a one-off incident can amount to harassment. So it's clearly unwanted conduct because Maria is shocked by it and upset by it. And I think we'd probably all agree that she's probably got reasonable basis for being shocked and upset by it. So it is reasonable to conclude that it's going to have an effect of violating her dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for her. So yes, that is in the yes camp.
Okay, thank you for that. So example 2, Andrew mentions to Debbie that he hurt his shoulder at the weekend. Poor Andrew. Without prompting, Debbie rubs Andrew's shoulder in the office on 3 occasions throughout the day. Andrew feels very awkward about Debbie doing so. Is this harassment? Please vote now. Ooh.
Less clear cut this time, I think.
So 85% of you said yes, it is harassment. 15% of you said no, it's not. So let's have a look at this. Is it wanted? No. Andrew feels very awkward about doing so. Does it violate his dignity? He's uncomfortable about having his shoulder being rubbed. What about the intention of Debbie? Does Debbie intend to harass Andrew? Does her intention matter here? As we will see, no, it doesn't. It's how it's received, not how it's intended. So on balance, I would say yes, this is harassment. It obviously needs to relate to a protected characteristic, as we'll talk about later, but I on balance would say, yeah, yes, it is. But there's some issues that we might pick up later about how it's received. Okay, Rebecca.
Okay, example 3. So Alan's 2 colleagues, Rita and Amanda, tease him regularly about being homosexual. Alan is heterosexual. Rita and Amanda view this as light-hearted banter. Alan is not upset by their remarks. So do we think this is likely to be harassment, yes or no? Yeah, much closer this time.
Far more balanced.
We appreciate we're asking you to do this fairly quickly, so we're holding no judgments on the outcomes.
I'm going to end that and share the results.
Okay, so yes, we're seeing much more closely between the yes and the no. So 62% yes, 38% no. So the answer is it's unlikely to be harassment in this instance, because the key point is Alan is not upset by the remarks, and so it's unlikely to have an impact upon him of violating his dignity or creating an intimidating, hostile or degrading, humiliating environment. But there is some exceptions to that, because the position would obviously be very different if Alan had been upset and offended by it. That clearly could amount to harassment. Also, there's long established case law that homophobic banter can amount to harassment even if the victim is known not to be gay. So that's a kind of a red herring. And also you've got to take into account where even if Alan isn't offended by this, others who overhear the conversation could also be offended and or could be offended and bring harassment claims on that basis. So I think, to be fair, both the yes and no's are right in that situation, but on literally the wording in that Alan situation, it's unlikely that it would amount to harassment.
That was such a lawyer's answer, by the way.
Well, I like to stick to my stereotype.
Okay. Example 4. Joel tells a joke in the office. Well, that's a bad start immediately, isn't it, really? But Joel tells a joke in the office which is derogatory against people from Liverpool. Sammy, who is from Liverpool, overhears the joke and is offended. Is this harassment? Off you go. Ooh, people are thinking about it a bit more now. Tracy, while you're all voting, Tracy, your question, yes, that should be fine. We'll send the recording out later and you can share it that way. Again, a bit more balanced. I'm going to close that and share the results. So 58% of you said that yes, you felt that was harassment. 42% of you said you thought that was not. Well, the no's have it on this occasion. No, that's not harassment under the terms of the Equality Act. Why is it not? Because the Equality Act looks at race being colour, nationality, ethnic and national origins, and local or regional origins are not within national origins. And there's the ACAS guidance on this makes that very clear. And there's actually a case called, I think, Ryan and Robertson, let me just check, yeah, from last year. And they said, in response to, I think it's, I can't remember the comedian's name, the one that does the calm down comments, somebody will tell me. And somebody was very offended by that, brought a harassment claim, and they said, no, it got struck out as no reasonable prospect of success because just being from Liverpool doesn't count as race discrimination and therefore harassment because it doesn't relate to a protected characteristic. Okay, last one.
Oh, sorry, I was looking at the questions, distracted. So Jonathan asked his colleague Mohammed if he is going to have another bacon sandwich. Mohammed is a Muslim. Do we think that could amount to harassment, yes or no? Very much closer this time.
I agree. Okay, I'm going to call that one.
Yeah, go for it. So I think this is a bit of a naughty one, really, but the answer is no, it's not harassment because the key point is the word another. So clearly Mohammed has already eaten a bacon sandwich. So Jonathan's question is merely a query of do you want another one? So it's highly unlikely to have any offensive implications there.
I'm afraid that was the devil is in the detail question.
Yes, that was obviously drafted by a lawyer.
Possibly me. Yes.
Yeah, I was not pointing fingers.
Okay. All right. So let's move on to. We've asked you to give answers. We're not holding you to those answers, and now we're going to tell you why those scenarios were either harassment or not harassment. So what is harassment? Well, it's a form of discrimination. So it covers all of the protected characteristics. Should I be unfair and ask you to recite all 9 of them, Rebecca?
Yeah, no, definitely not. I always get stuck on the last few when I'm trying to do it.
So you're saying it wouldn't be unfair for me to ask you?
It would be unfair, yes.
Okay, all right. Sex, race, I'm looking down at my notes. Disability, age, gender reassignment, sexual orientation, pregnancy and maternity, religion and religious belief, and marriage and civil partnership. Now, harassment covers all of those except marriage and civil partnership and pregnancy and maternity. Don't ask me why. So we have the usual definitions of discrimination with being direct, indirect, victimization, and harassment. And for harassment to apply, it must be more than just bullying, if I use that word. It must relate to a protected characteristic. Now, everybody has a protected characteristic. Everyone has an age and a gender. So you might be able to peg it to one of those, but you may be able to peg it to others, and it could be many. Now, one of the things that are hallmarks is that it must be unwanted conduct. And we saw from one of those scenarios, was it Alan that was happy with the comments, Rebecca, in that scenario? So if it's accepted, it is not harassment. That kind of makes sense, doesn't it? So it has to be unwanted conduct. So as I say, related to a protected characteristic. But then, and this is the phrase that Rebecca has been using a number of times this morning, it has to have the purpose or the effect, and I'll come back to those points in a second, of violating the person's dignity or creating a hostile, degrading, humiliating, or offensive environment, which is a pretty wide scope, if you think about it, of am I going to be upset by this? And most of the time you can come in within those points. So let's just look at that in a bit more detail. So we mentioned earlier that it's not that I have to intend to violate someone's dignity or create a hostile, degrading, etc., etc. For ease, so to avoid us having to recite those phrases, I'm just going to call it violating dignity, but I mean by that both of those limbs from now on. Okay, so intention isn't there, so it's about how it's received, not how it's intended. So if I say to Rebecca something which in my head is perfectly acceptable but lands very badly with Rebecca, I have checked with Rebecca that I can use her in this way, and she said it was absolutely fine, then it is not that I intended it to be banter and therefore humorous, it is how Rebecca receives it. Now, if my purpose was to harass Rebecca, so to use the Debbie and Andrew example of rubbing the shoulder where he's had an injury, that the purpose of that wasn't, you would argue, to harass, but the effect on him was that he felt uncomfortable and awkward about that. So the purpose is going to harass somebody, then undoubtedly it's going to, if it relates to a protected characteristic and it's unwanted, it's going to end up with it being harassment. If the effect is that it's harassment, so I rub Rebecca's shoulder, for example, that could have the effect of that. And that's a subjective test. How Rebecca receives that depends upon her feelings on that. So it's a case of, what is it reasonable for Rebecca to think about that? We take into account the circumstances, so perhaps an imbalance of power, seniority of the two individuals. But we also look at, is it reasonable for Rebecca to take that view? So is she being, for example, hypersensitive? Don't really like that term, but so to use this as an example, I rubbed Rebecca's shoulder at work. I don't intend that to be harassment, but Rebecca may say, the effect of that is to create that violation of her dignity. Is she, though, being hypersensitive about that? And is it reasonable for me to do that? Now, if she says, no, James, which is not normally how Rebecca would respond, and I carry on doing that, then clearly the flare has been sent up and we all know where we stand. If she doesn't make that clear, it's always much harder to establish because you don't have that clear signal. So one-off events can amount to harassment. A sequence of events can definitely amount to harassment, but we have to take into account where it's not clear the purpose, what the effect is, those two stages of how the person receives it and the subjective test and the objective test of are they being effectively oversensitive. Difficult to navigate your way through that a little bit. Rebecca mentioned earlier about association and perception. So you can have harassment by association. So a good example of that is a group of people who have a protected characteristic. For the sake of example, let's say they are gay. Fred is not gay, but he is offended. He's harassed because he's associated with them in that sense, or he believes he is offended because the gay people are being harassed. He can establish that protected characteristic because it's not the person's protected characteristic, it is harassment relating to a protected characteristic. And then similarly with perception. Now, all of this is interesting, but what does it have to do with employment lawyers? Well, funnily enough, because it results in claims. and individuals can bring a claim in the employment tribunal if they believe they have been the victim of harassment, and they have to do something about that belief, and they have to do it so within 3 months. They have to go to ACAS to go through early conciliation and then onwards to the employment tribunal. So it's of the event, or if it's a series of events, of the last of that series of events. And if they then go to the tribunal, they'll be seeking financial loss, i.e. loss of earnings, and injury to feelings. And the employer, as I suspect many of you know, can be liable for the actions of its employees who are harassing other employees. And there is something called a defence to that, which is a reasonably practicable steps defence. And Rebecca is going to cover that in a bit more detail momentarily. But it's not just about employment tribunal claims. There's also individuals can bring personal injury claims in the civil courts. If they are being effectively stalked, there's protection from Harassment Act, and obviously harassment can feature in other claims such as unfair dismissal and potentially failing to provide a safe system of work under the Health and Safety Act. So we see a lot of this, unfortunately, at the moment. And one of the things, it's not on the slide, but I wanted to mention is individuals who believe that they've been the victim of harassment can bring claims against their employer, and say the employer, who typically will have the deeper pockets, is liable, but they can also claim against an individual. I saw this yesterday where ACAS were contacting the individual manager as an individual named respondent. So quite often it's used as a tactical gesture or exercise, sometimes with good reason, because Fred or Ginger as an individual has done something heinous, and that person can be personally liable. And then you have the old issue of if you're acting for the company, do you act for the company and the individual, or do you have a potential conflict if you don't believe what the individual has done is appropriate, and whether you're going to run the reasonably practicable steps defence. So we see a lot of that. It's very compelling because it focuses everybody's minds where you get individually named respondents. What the individual who believes they've been the victim of harassment can't do is just bring a claim against an individual named respondent in the employment tribunal. They have to go to the employer and then against the individual. Okay, I think enough of that. Bit more on reasonable steps defence, please, Rebecca.
Yes, so I would just echo James, though, in terms of reasonable individual respondents, it can create quite a tricky issue for the employer as well, and they probably need to have procedures in place to think how they deal with that and consider any conflicts, and sometimes you get into indemnities and all sorts in terms of how you approach that. So it is a sensitive issue that you need to tread carefully on. So reasonable steps defence. What is the reasonable steps defence and how can employers use it? Well, as you'll be aware, under the principle of vicarious liability, an employer will be held liable for the actions of their employees in the course of their employment. But when we're talking about discrimination, there is the exception to this where you can run the reasonable steps defence. And this is under section 109(4) of the Equality Act, and it gives employers a defence to discrimination claims if they can show they have taken all reasonable steps to prevent discrimination in the workplace. Now, this is a high bar, it always has been, but as I'll go into in a little bit more, it's probably got a little bit higher, the trend, and you have to make sure you're taking preventative steps before the discriminatory act occur. That probably sounds obvious, but it's about creating a culture in your workplace, doing all you can to minimise and mitigate the risk of discrimination occurring. So employers usually think if they've given training and have the right policies in place, that they should be protected, but we'll see from the next case that it's not quite as straightforward as that, and some further thought does need to go into it. So in the case of Ali versus Gellin, James, next slide. Mr. Gellin was of Indian origin and he'd been subjected to racial comments by his colleague Mr. P. There wasn't any question that he had suffered discrimination by Mr. P, but the employer ran the reasonable steps defence and said they shouldn't be held liable for Mr. P's actions because they'd done all they reasonably could to prevent Mr. P's behaviour. Unfortunately, at the tribunal, it came out that the comments had either been overheard or reported to managers at the time, and the managers hadn't done anything about it, so hadn't escalated it. And whilst Mr. P had undergone equal opportunities training, it was several years earlier before the event occurred. So the Employment Tribunal looked at it and concluded that there was discrimination, which I don't think was probably ever really in doubt, but that the employer couldn't rely on the reasonable steps defence. They found that they hadn't done enough and that the training that they had given was effectively stale, and there was various reasons for that. The employer appealed to the Employment Appeals Tribunal. They took the view, we've given training, we've got the policies in place, what more could we have done? The EAT looked at it, but they upheld the Employment Tribunal's decision. They felt it was reasonable for the Employment Tribunal to conclude that the employer hadn't done enough. So it also took the opportunity, helpfully, to set out how the defence should be assessed when you're looking at it as an Employment Tribunal judge. And there was 3 steps, effectively. Firstly, that they should identify any steps that the employer had taken. So what had they done? Consider whether those steps were reasonable, were they likely to be effective or not? And finally, and this is the bit where the bar gets higher, consider whether there were any other steps that the employer could have reasonably taken. So not only what did you do, was that enough, but also was there anything else you reasonably should have done? And so you can see that kind of pushes it up a gear as to what you should be doing, if not just what you have done, but is there anything else you should have been doing? Here, whilst they had policies in place, so LA, they weren't robust enough in the EAT's view and the Employment Tribunal's view. For example, the Equal Opportunities Policy didn't make any reference to harassment at all. And the Anti-Bullying and Harassment Policy only referred to harassment in the title and made no reference to race. I found that particularly surprising. So I think it's fair to say that they weren't the best policies in the world, and they weren't probably very robust. When they then looked at the training, as I said, Mr. P and the managers had undergone the training, but it was a few years before, and the EAT said that training had effectively become stale. That was a reasonable conclusion for the tribunal to make. Though interestingly, they weren't giving a specific time frame that you need to keep redoing the training by. They said it will depend on actually how effective the training was in the first place. Did it have a lasting impact? How good was it at actually making employees understand what they should and shouldn't be doing? And the fact that not only had Mr. P made these comments was an indicator that the training hadn't been very effective for him, but also that the managers hadn't escalated or done anything about it when they heard the comments, suggesting that their training wasn't very effective either, because appropriate steps haven't been taken. So I think this decision highlights that it can't be, if you want to rely on the reasonable steps defence, it can't be a tick box exercise. So it's not about we've done the training, we've done the policies, job done. It's wider than that, and actually looking at, is it, what reasonably can we do? Is it creating this culture of ensuring that we minimise the risk of discrimination as much as possible? And what it's reasonable for an employer to do, how far they have to go, will vary between employer and depending on their size and the resources available to them. The tribunal do take those factors into account. They also will look at risk factors in particular industries and whether the steps are taken to address those. So you can imagine in some industries there are specific types of harassment that are more at risk of occurring than others, and that needs to be taken into account when you're planning how you address the risk of discrimination occurs. So what kind of things can or should employers be doing? If we're saying just doing the training and having the policies in place isn't going to be enough, well, I think clearly training is needed, but you need to make sure it's effective, it's tailored to your organisation, and it's not just a tick box exercise of having an online training course. And how do you do that? Well, you need to review and see if it's actually having an impact upon employees. So does it actually mitigate the likelihood of discrimination? That is, I accept, quite a difficult thing to measure, but the tribunal have indicated that you should be monitoring the number of reports of discrimination that are happening in your organisation, and actually also drilling down into that and seeing how many of those reports are coming direct from employees versus how many are being escalated by managers, so you can see whether managers are doing their bit as well as employees, instances of employees making discriminatory comments. And it might be, for training to be effective, you need different types of training depending on the job role. So managers who have to deal with these having more responsibilities for the policies and things, having a different kind of training to the operatives. Also, you've got the responsibility to actually review when something goes wrong. So the internal grievances, even if it doesn't result in an employment tribunal claim, actually do we undertake a review of how many discrimination claims coming in, and if they are, have a look at those and assess whether our policies are being followed. Is this coming from the employees themselves? What's the process that is followed? You could also look, because obviously it relies on people feeling empowered to actually come forward and make the report, that kind of monitoring. You could look at doing anonymous surveys, to asking people anonymously, do they feel able to make a report? And also, have they been subjected to any kind of discrimination in the workplace? All of those things will then be documented, enable you to help support to a tribunal that you are doing all you can, that you're not treating it as a tick box exercise, you're keeping it under constant review, and you are taking what steps you can to mitigate the situation. And you'll need to ensure it's not a one-off review that you do, that this is regularly reviewed as things progress, technology develops. Is there anything else you can be doing from a reasonable steps perspective? And interestingly, for example, you could even include performance objectives for managers to deal appropriately with complaints of harassment. I mean, you'd hope they wouldn't come up, but that if they do, that they know how to deal with it. And also regularly reminding people that policies are there, making internal announcements and making people aware of where the policies can be found, etc. It's all those kind of steps, and making sure you're keeping a record of that, and also reviewing what has and hasn't been done and how effective it's likely to be. I appreciate that is quite a lot to ask of an employer, but why are we saying this is important? Obviously, you won't be able to rely on the reasonable steps defence, but that was always quite a difficult thing to do. I mean, I can say my career, there's very rarely that I've successfully run a reasonable steps defence, but as we'll see, we've got a proposal from the government that actually goes a bit further than that and is flipping it round to a positive duty. So in July 2021, the government published its response to consultation on sexual harassment in the workplace. And whilst that was primarily prompted by concerns around sexual harassment, the government has made clear that any new measures will extend to all forms of harassment prohibited by the Equality Act, not just protected characteristics of sex. Now, there are various key proposals that will come out that I'll run through three of them, but the first one is that they are proposing a new duty requiring employers to take all reasonable steps to prevent harassment in the workplace. So whilst we don't know exactly the scope of that duty, we can anticipate that it's likely to be reflective of the reasonable steps defence, but flipped to a positive obligation upon employers to do that. So not only is it, okay, we won't have a defence in an employment tribunal if we don't take all reasonable steps to try and mitigate any discrimination in the workplace, will actually come under a positive obligation that we are under a duty to actively do that. And the proposal is that the Equality and Human Rights Commission will be responsible for enforcing this new duty. So it's always a little bit difficult to know what the kind of teeth, the consequences will be. So that'll be interesting to see if there are any really kind of tangible one. But one obvious one will be that it will make it a lot easier for employees, to use any failings by an employer not to take reasonable steps to mitigate discrimination in any discrimination claim, to show the kind of culture and atmosphere at the employer and why such behaviour occurred and why it is discrimination and should be awarded money accordingly. So it is something that will need to be a focus in employers. Obviously, all of these proposals, and I'll go through the other two in a second, are to be introduced when parliamentary time allows. So let's be honest, at the moment, we've all got sympathy that there's probably limited time available to deal with these types of things, but they have committed to introducing this. So subject to any government changes, that will be moving forward. And hopefully we'll get a bit more detail as to what that would look like. The other two key proposals is one to reintroduce the specific measure to protect workers from third-party harassment. So some of you may recall that there used to be in the Equality Act a provision that prevented third-party harassment, and that was repealed back in 2013, I think, so quite early on. But case law as well subsequently has recognised that actually in most circumstances an employee won't have a claim currently if they're subjected to harassment by a third party who's completely unrelated to the employer. The government want to plug that loophole and make employers responsible for not just its employees' behaviours, but also third parties who the employee comes into contact with during their employment. We're not clear how they will address that issue. It's unlikely to go back to the original duty under the Equality Act, because that was a 3 strikes kind of approach that required there to have been 2 instances of harassment before the third occurred, when liability could actually be attributed to the employer. That's probably why it wasn't very effective, because you'd like to think if 2 had already happened that the person may well have left by the time the third comes up, but it wasn't widely used. So I'm not sure how likely they'll revert to that, but I suspect they will require some kind of knowledge on the employer's part that harassment is likely to take place, rather than just a complete kind of strict liability approach. So it will be interesting to see how they develop that. And finally, they're considering extended time limit for bringing discrimination claims up from 3 to 6 months. They've stopped short of committing to changing the rules, but they've said they will be looking closely at it and the possibility of extending it.
Thanks, Rebecca. So also coming out of that are some points about confidentiality clause in NDAs, which the government are looking at and trying to tighten, and potentially looking at making a specific obligation in the Employment Rights Act, where there is a settlement agreement that the advisor has to advise on the terms of the confidentiality, which is quite interesting. And if the NDA, the confidentiality term, breaches this, then that bit is void, not the whole of the settlement agreement, but that element is void. So they're trying to put greater focus on this to stop there being a misuse of NDAs. ACAS in particular are quite strong on this, strongly believe that NDAs have been misused and can be misused, and really cracking down on, yes, you can have a settlement agreement, yes, you can deal with where there have been allegations of harassment, and yes, you can wrap it up with some confidentiality, but you've got to do it within the scope of what the law allows and how that's going to be extended. Now, for those of you on the call who are in-house advisors and are solicitors, so our regulatory body, the SRA, there is a warning notice which you have to heed, which basically says if you are doing a settlement agreement or a COT3, you have to be mindful of the requirements of the warning notice, which in essence say you cannot stop somebody from going to a regulator, you can't stop them going to the police. And there are specifics in there so our settlement agreement that we produce is within the terms of the SRA warning notice, but quite often if it's just something that is drafted up by somebody who's looked at the requirements of Section 203 of the Employment Rights Act, that won't necessarily comply with that, but they're not regulated by the SRA. So there is a greater duty on legal advisors in that respect, which I think makes sense. We are slightly tight on time, so Rebecca, quickly on other developments, please.
Yeah, so there's the proposal that they're going to launch consultation on requiring employers to give a minimum reference, so a factual reference, to address the issue that people who suffer discrimination may suffer if they don't get any kind of reference at all. And also on the Equality and Human Rights Commission technical guidance on sexual harassment and harassment in the workplace is likely to become statutory, which means that tribunals can actively look at it and take it into account.
Thank you. Right, we've had a couple of questions which we'll just pick up now. Before I do that, I'd just like to say, so we've focused a lot on sexual harassment. Harassment isn't just about sex. We've covered that in relation to all the different related characteristics. What would I like people to take away from this? That this issue, harassment in the workplace, is still there. There is a lot of developments coming through which are going to tackle it because it's still there. And as employers, we need to be very mindful of that. And if we want to avoid being liable for the actions of employees who harass their colleagues, we need to look very carefully at how we can establish our reasonable practicable steps defence. As Rebecca has shown, that's not easy, but otherwise you are left holding the purse strings for individuals who are doing things they shouldn't be doing. So a couple of questions. Alice says, is there additional legislation beyond the Equality Act? The Equality Act is just dealing with discrimination. So if somebody is bullying, harassing somebody and it's not relating to a protected characteristic, then it's not discrimination and therefore harassment under the Equality Act, but that doesn't make it acceptable conduct. So absolutely, but then you'll be looking at your usual policies about raising grievances and dealing with that, and ultimately the individual might claim, say, constructive dismissal. So you could still have bullying on that.
I think that addresses the second question as well around the regional potential. So our example, yeah, that is a very legal point, that regional characteristics aren't covered by the Equality Act. But as an Essex girl, I can relate to you know, Essex girls jokes and things like that being thrown around. And actually, when you're if you're trying to meet the reasonable steps defence, realistically, you're probably not going to distinguish between and say it's okay to you know, make comments about someone's regional background, but you can't make comments about someone's national background. I think the more reality is that you want to create an environment when any of that kind of offensive banter is as labelled is not acceptable, and that's the issue you're trying to address. So I suspect whilst it is relevant if you ever got to a tribunal claim, actually in terms of trying to address it and meet the reasonable steps defence, you would cover all of those angles and you wouldn't be highlighting the distinction.
Okay, thank you. Just pick up the last couple. Does it matter whether the harasser knows whether the victim feels degraded? No, is the short answer. That goes back to that intention point. If you genuinely don't know that it's had a direct derogatory effect, okay, but that person may still feel that they have been degraded. So it comes back to that subjective and objective test. And then lastly, what about a case of ignorance? For example, if you invited someone to lunch during Ramadan without knowing it was Ramadan and someone took offence. I think that there is some ignorance there, maybe that you haven't appreciated that if they do take offence at that, yes, but then you come back to the objective element of, are they being too sensitive about that? I think that's slightly difficult, and there's an argument that perhaps we should know that it's Ramadan, but I appreciate that not everybody does.
I think as well, there's probably a distinction between the disciplinary action you take against the employee because of how they've behaved, and whether you're looking at zero tolerance kind of dismissal level versus the intention probably will be relevant to that aspect of it, but actually whether the employee has suffered harassment or not, that is going to be alive to it, and you should be trying to take steps to educate people about potential risk areas. And the tribunal would expect, I think, to see that, you know, if you've got certain issues arising, that you might try and highlight it in the workplace so people are aware of the potential sensitivities there.
Yeah, agreed. Thank you for that. All right, I'm gonna conclude us. Thank you very much for joining us this morning. Really appreciate your input in the Q&A and answering our polls. We hope you found this useful. If you have, please complete the feedback, which will pop up as you leave. If you haven't found it useful, no, do still complete the feedback, because we like all feedback, constructive or otherwise, and all gratefully received. Thank you very much, and we will see you next time. Cheers, Rebecca.